Good afternoon and welcome everyone on behalf of the Wagner Law Group. This is Steve Wilkes in our San Francisco office. Welcome to today's webinar. We're going to talk a little bit about executive compensation in the nonprofit sector, 501c3 organizations or C4 for the most part. At our last webinar, we were into kind of a subset of this. We spoke about 457F, and I might mention that in there, but we've had a lot of feedback from our nonprofit clients and from our advisor community in general that has nonprofit clients, just to continue to talk about, some of the broader areas of benefits and compensation, in addition to, 403B type things. So that is why we are addressing some of these topics. I'm glad you're here with us today. So, I'll have a few opening comments. We'll talk a little bit about some of the process and procedure, kind of from a board of director point of view maybe. And then a lot of this, as you'll see, is really governed, is very tax sensitive in terms of the 501c3 kind of rules. So we're going to talk about some concepts about private benefit and private inurement. We're going to talk about some of the excise tax sanctions if you get out of whack on your executive comp program, a little bit about what reasonable might mean in terms of a nonprofit entity, a little bit about, kind of rewarding executives in a nonprofit in terms of some incentive or performance, a little bit about the reporting, which comes on the annual IRS Form 990. And then, of course, these programs aren't limited to being, a bonus programs. There is a deferral aspect that we can talk about if you'd like. And again, we've mentioned that a little bit in our last webinar with 457, but we'll just kind of highlight, a couple of things on the deferral side that you can embellish these programs with. Come back to a little more process and then just kind of wrap it up from there. So I think, first of all, why this topic? Why are we talking about executive compensation at nonprofits? I mean, clearly, executive comp is a very important issue, for nonprofit corporations and public charities, and it's kind of a challenge, I think, for these organizations to deal with executive comp because you have to try to configure and balance, the kind of the mission of your entity and the overall purpose with whatever financial constraints you have in terms of your ability to pay people, with the important aspects of, hiring and keeping, your best executives online to deliver the mission on behalf of your entity, and, maybe to reward really exceptional service. And this is all against a backdrop of a very public eye, because people always look at public entities and public corporations, nonprofits, a little bit differently than the private sector. So there's a lot of issues to talk about, and there are different parties involved. For those of you listening that are advisors, this is an area where you're not necessarily gathering assets the way you do in a traditional 401k, 403b. If it's a bonus plan, there's no asset gathering. If there are deferrals, maybe it's going into a rabbi trust or something. But still, I always say, and we always say at the Wagner Law Group, as the trusted advisor on so many of these issues to the entity, we think that you have an opportunity to add value to your clients by being conversant with these different programs and concepts. Of course, the employer, has a role in this. You have to think about, just having programs in place for your executives, for your team. And there's a lot of things come to play. These are very much creatures of the tax law, and unlike a profit corporation, where you have certain rules on deductibility and what have you, here you have kind of a different set of rules in terms of tax that need to be thought about in terms of preserving the tax status of the entity. You have some general governance kind of considerations in terms of how you implement these things and stay aligned with the nonprofit statute, in your state. And maybe, your mission statement. There's a tremendous demand for transparency from the public. So there's a lot of things to think about. And we have found in our experience that a lot of times the senior execs and the board members at nonprofits aren't totally up to speed, aren't totally conversant with all these little factors that go into, having a an executive comp program at the entity. So it's an area that we all need to keep our learning curve up on. In terms of who does this really matter to? I think clearly, as I said before, the IRS has a very strong interest in this. Executive comp it's kind of always been something that they're interested in the corporate world, and clearly nonprofits are no exception. When you take a look at that, at the Form 990 that you have to file, and you kind of see the kind of information that's required, it really gives you the visibility into how deep that they're really digging into a lot of this stuff. I mean, these Form 990s have all kinds of disclosures about the composition of the board, its management structure, how you promote people, a lot of compensation information about certain officers and directors who earn more than a threshold level. I think it's 150 at the moment. And if you don't answer, just like in the retirement plan world, when you file your Form 5500, in some ways it might trigger an audit. I think these 990s are kind of a roadmap for the IRS in terms of spotting and maybe enforcing some of the rules on excess compensation. So they've taken on a real big role. And the IRS clearly, when you look at all their speeches that they're giving and kind of just track their public pronouncements over the last couple of years, it's clear that they're really focusing on exempt organizations, and they're not looking for executive compensation, because that's okay. They're looking for impermissible levels of comp. They're looking for excessive comp, and maybe the excise tax that goes with it. So clearly a lot happening there. Your donor base is going to be interested. I mean, they just want to know how the dollars are being spent. What percentage of each dollar is going toward the kind of the mission statement of the organization. And when someone makes a substantial contribution, they really want to know it's going to be used in that way. Your competitors are curious. You're kind of a benchmark for them. Compensation is, you're competing for certain employees. Compensation is one of the things that you might compete with in terms of getting those people. So clearly your competitors are involved. And obviously the employees themselves. I think the people in the organization as a whole are kind of interested as what the compensation is structured like, especially at the top of the house. You might have some rank and file people who kind of wonder what the people in the executive suite are making. It's kind of a leadership. It's kind of a reflection of how they're leading, maybe, and how the board values people. And of course, there the tax consequences to the individual recipients. So there's a lot there are a lot of constituents to this, and the implications. You either get it right or you get it wrong. I mean, clearly there's a tax status implication, because the potential of losing your tax exempt status is there as a 501c3 or C4 organization. The IRS does have that ability. They can always argue that assets aren't used for private benefit, or you violated the ban on annulment. We'll talk about that a little later. You're going to have just individual. The management team is liable for being part of the process that approves these decisions, the governing body, if you will. And there could be a taxation on disqualified people who receive the benefits. There could be culpability on behalf of the because of the management team's involvement. So it really gets around. And finally, at the end of the day, maybe the million-dollar question is, what is reasonable? What's reasonable compensation? And that's kind of a hard thing. It's one of those facts and circumstances. There's no real clear answer. There's lots of criteria that's involved. I know the consultants always talk about the magic 50th percentile, or being above or below that. But clearly, in terms of compensation, the IRS always is going to try to put some kind of value on the benefit and to see what's been paid. They look at cash and non-cash values of things. So there's a lot to be considered from putting together one of these plans. Now, I want to talk just a little bit about, I'll just call it process and procedure, before I jump back into some of the more, IRS technical things, if you will. And I just want to say that, as the fiduciaries or the stewards of a nonprofit, the board or the management team, I think they have a lot of responsibility as to how every dollar that's taken into the organization is spent. So I think any good board or any good management team is going to have some processes and procedures in place for executive compensation. We're not going to detail the entire thing today. That's the run. There's some very good consulting firms that really work on that. Of course, as lawyers, we get involved with it as well. I think there's lots of good resources out there to kind of check where you're at. But clearly, I think, you need to ask yourself at the organization, first of all, do we have a process? Are we just ad hoc, or do we actually have a process here, that kind of talks about, the role? Do we have a compensation committee, and what are its responsibilities? And how do we get the right kind of data so we know how we're paying people, and how do we evaluate performance of our executives, and do we understand what needs to be reported to the IRS in Form 990, that kind of thing. So, and then once you have a process, of course, the danger of having a process is that you have to be able to show that you followed it. You have to comply with it. So I think you need to have a process to show that you're following the process, if you will, or make sure that you're actually implementing, these policies and guidelines. That's really important. And then, there's just a lot of best practices out there that generally turn on the question of, benchmarking against other organizations in terms of, bands of compensation and valuing services and what's appropriate for a certain size organization or a certain level, and also independence. I think the idea that a lot of these decisions are made, independently, and they're not, kind of wrapped up in the wrong kind of relationship, is something that's really important. So process and procedure behind all this stuff obviously is very critical. So there's a ton of rules here. I mean, basically, when you get down to, okay, so where are the rules? I have to open up the tax code. Where do I go? What are the rules for this kind of thing? I think that, at the end of the day, you can say this stuff really falls under the rules for 501c3, because the tax code, what it says is that, for these tax-exempt entities, it says they have to be operated, exclusively for certain purposes, and that no part of the net earnings, can inure to the benefit of any private shareholder or individual. So this kind of means that you end up with a requirement, a limitation on the private benefit, which means that the assets have to be used exclusively for a charitable purpose. If it's not, that's okay, except you're not going to be a tax-exempt organization anymore. So I think that's one concept that's kind of built into the legal parameters for structuring these things. And the other concept is, the prohibition against private inurement. And what they're really saying is that an organization that's, really not operated primarily for an exempt, well, they're saying that an organization isn't really operated primarily for an exempt purpose if the net earnings in whole or in part go to the benefit of any private person. And, a private person would mean someone with a personal or private interest in the activities of the organization. So typically there's a red flag in this if you can't show a connection between the payments received and the value of the service provided, or if there is a connection, the payments are really out of proportion. And there's a bunch of really leading, I think these are usually I haven't all been tax court cases. I get a couple of tax court cases. One involved the Church of Scientology. That's a leading case. So there's a lot of knowledge out there on this, but it's very fact specific. When you go through all the cases and all the rulings, you end up with a lot of fact patterns that provide for a lot of different opportunities. So again, just I would just say private benefit occurs when the organization is organized, or seems to be operated for the benefit of a private person, and that doesn't seem to constitute a charitable. That person is not part of a charitable class, if you will, and it really looks at whether this money is being spent for exempt purposes as opposed to private purposes, I guess. So those are two key concepts that we would talk about: private benefit and private inurement in terms of structuring these. Now, what happens? Now, it used to be that the only tool the IRS really had was to pull your tax status. and they don't really do that anymore. So, well, they can, but they developed an alternative. I mean, basically, there's an excise tax that's available, and that imposes a system of excise taxes where you have, what's called an excess benefit transaction involving a disqualified person. And I think that was in the late 90s. I want to say around 96 or 97 that excise tax came into being. And before that, all they could do, the only tool they really had was to threaten your tax status. So the tax status is it's kind of a tiered tax. It's imposed on disqualified persons who benefit from an excess benefit transaction, but it's also imposed on the organization managers. That's why I mentioned before that it's not just the entity or the employee, but the organization itself, the managers who participate have some risk as well. So a disqualified person, subject, there's a first-tier tax equal to 25% of the amount involved. Then if it's not corrected, it jumps up to a second-tier tax, and it can get pretty hefty. And it, needs to be corrected within a certain amount of time, or else, like I say, it layers up. On the organizational managers who might have, participated in it, that's a tax equal to, percentage of the amount of the benefit, up to a maximum penalty, 10% of the amount of the benefit. So there are some outs. They make clear that, managers can be forgiven if they're relying on a reasoned legal opinion from attorneys, or CPAs can also provide that with tax expertise or maybe evaluation. So I think that's something to consider if you're to get some documentary support to protect your management team on these. A disqualified person, by the way, is pretty much anyone that's in a position to exercise influence over the affairs of the organization. And there are different categories. You have to look at family members, voting members of the governing body, certain officers. In addition to some per se defined classes, there's also more a subjective definition. People that have maybe a certain amount of influence over the organization are going to be deemed as well. So the tax can roll out under two kinds of people: disqualified person or organization manager. The thing about the excess benefit transaction, I guess you need to think about it as being, I guess I would say it's a transaction where the entity is giving an economic benefit to a disqualified person that exceeds the value of what they got back. That's probably the easiest way to describe it. So then in terms of value, well, how do you value the transaction, or the valuation becomes really important, because they look at, compensation includes all, you have to kind of look on an all-in total basis. Compensation includes all the economic benefits that are provided, and there's some things that are excluded. Expense reimbursements, obviously aren't counted, and there's some other exclusions. But basically, you're looking at salary and fees, bonuses, severance payments, deferred benefits, payments that provide any kind of health benefits, things like that. So it can be a pretty exhaustive list. Now, there is a concept in this tax area, called a rebuttable presumption of reasonableness, and it's really important. And basically, the IRS regulations say that we'll give you a rebuttable presumption in your favor, if you can satisfy certain requirements. And these requirements would be basically that the arrangement was approved by an independent board of directors. Notice how we're coming back to that concept of independence. That they relied on, good data, appropriate data for comparability, and that they documented the decision-making properly. So there are some ways that you can build up this rebuttable presumption, which really go in your favor if you're, if you're on audit or something like that. Now, reasonable compensation, again, that becomes a threshold question. What's reasonable? Generally, I think here in this nonprofit world, I would say that reasonable compensation tends to mean the same thing that it did kind of over on the corporate side when you're looking for a deduction under, for just a regular old bonus plan for a taxable entity under Section 162. There's a lot of definitions on it in the case law, and for excise tax purposes, there's also, it can be found in, in the code and the regulations. So what you want to be doing again is, you want to be benchmarking to similar organizations, making sure you get a good value on the service, and you want to be considering all forms of compensation. And there are some exceptions. There's something which we call the initial contract exception, and that means that the excise tax doesn't apply to a fixed payment that's made to a person pursuant to their initial contract unless they fail to perform what they're supposed to do. So that's something that could be helpful. Sometimes we also see where you have a plan where there's some kind of incentive in place, revenue sharing transactions, I guess we could say. They may be. They clearly, the IRS has the authority to look at some of these, performance-oriented or revenue-sharing, percentage of kind of compensation plans as having the potential to be a problem. So again, you have to look very carefully at these, and there's a lot of regulatory definition. Not specifically on it, but you can infer some things from the regulations. But there are certain standards out there in terms of fair market value that are applicable to organizations like this, and that'll really be helpful, I think, in terms of identifying. Timing gets to be an interesting thing here. You have to look at in the case of a fixed payment, you have to look at the availability of the rebuttable presumption under the timing rules for determining what's reasonable. In other words, at the time they entered into the agreement, that would be the time frame that you would put on it. Just overall, so what are the concepts? And the IRS always wants to know, is it reasonable? And just paying this executive, this benefit, or paying these executives under this plan, does that somehow aid the organization to discharge its exempt purpose? And the factors, well, they're pretty common sense. They're looking at they're looking at they're looking at what's reasonable. When you look at benchmarking, they want to see arm's length negotiation. They like to see, again, that independent governing body that granted the benefit, good comparables. They like to see some limit. It can't be an endless or totally open program. There has to be some sort of ceiling or cap. They like to see that anyway. Again, something in furtherance of the purpose of the organization. Some valid business purpose for having it. In other words, something is achieved as a result of paying this executive, and there has to be some earning of it based on performance. It's not really a private venture between a JV between an individual or group of individuals and the entity. It's not a scheme just to kind of funnel assets out of the company, and it can't impair the ability of the organization to perform. Or in other words, you can't see a reduction of services or benefits from the organization as a result of having this program. Now, the IRS, there's the tax return. There is a tax return, if you will. There's the Form 990, and if you ever looked at one really, really closely, there's tremendously detailed questions about compensation. So the old Form 990 used to be a lot easier, but they redesigned it back in I think the end of 2007, beginning of 2008. And they wanted to make sure that a lot of information was collected, but it also was important to address the concerns that had been coming in about tax compliance objectives and just transparency. So they're asking for all. Suffice it to say that they ask for a lot of detailed information on there. They ask you to identify any excess benefit transactions. They ask you to identify who's on your board, who's your officers and executives, how are they paid, how much time goes in. So it's really, again, something that you want to be careful about, that you obviously you need to report it properly, but it's the kind of thing that could really flag an audit if you didn't give a lot of careful thought to the preparation of it. Again, just today, you can take one of these plans and we could build some deferral elements on it, make it look more like a deferred executive comp plan. We mentioned 457F at our last webinar, or the traditional 457B plans. You always have to think about, the restrictions on the 409 Cap A and the ability to defer, and kind of the valuation issues that go along with restricted property to the extent that they're used. In fact, they just came out with a new set of regulations within the last month, kind of an updated set of regulations in Section 83. So that's an area that the service still pays a lot of attention to. So we talked a little bit, we're coming up on 30 minutes. We talked a little bit at the beginning about having a process in place. I just want to come back a little bit to process now and just kind of remind everyone that the things that you need to be thinking about here, kind of in terms of, I guess in terms of governance, if you will. You have the IRS requirements that impact your status under 501c3 or C4 or whatever your form of organization is, and the potential consequences of losing your status or being taxed. But you also have nonprofit statutes in the state you're operating in, and those have to be considered as well, because a lot of time, a lot of conflict issues and mission statement issues, formation of your board, definitions of independence, how you have certain transactions consummated, and when people have to recuse themselves. So there's a lot in the state law as well. I didn't mean to play it short thrift today, but I think the IRS had a little more stuff that was relevant in terms of compensation directly. You also want to think about just kind of best practices out there in the world. There's a lot of good organizations that you can get, literally you can get bylaws and things from some of the more transparent organizations that are really pretty cool. A lot of people look at the stock exchanges. Yeah, I just read the book, the Michael Lewis's book on flash trading over the last week. So I'm not sure I want to necessarily. I'm not sure if I can hold up the stock exchanges anymore. That was quite a thing to read. But actually, if you look at the published rules of the New York Stock Exchange in terms of governance and things like that, they really stand on their own, I think, as being good examples of independent fiduciary activity. The things that are particularly helpful in there are probably the formation of having a compensation committee or a little subcommittee of your board. They talk about independence, having good written policies, just how you review and approve performance and make recommendations to the board and compensation. Those translate pretty well to the nonprofit world. The Delaware corporate statutes are also generally viewed around the country as being pretty important. Finally, obviously, in terms of government, at the end of the day, a lot of this stuff will end up in your executive's employment contracts. So that's the place where a lot of these provisions and concerns will also be implemented and subject to review by the IRS or someone if they ever came along. So I think this is a great opportunity. Nonprofits, organizations have these programs. There's a lot to think about under the tax law in terms of how you do it. So going forward, what can you do? You want to protect your executives, the organization, the board. You just want to do it in the right fashion. So I think you want to really understand, the concept, the regulatory concept of rebuttable presumption of reasonableness and do things that buttress that. You want to make sure that your process and proceed, if you're able to avail yourself of it, you want to make sure that you can really show some independence in your decision making and that you have good benchmarking data. Clearly, using consultants, your CPA, legal counsel in certain instances will really be helpful. And take a look at a form before you develop your executive comp program or your individual executive comp contract next time at your entity. Go back and take a look at the questions they're asking in a Form 990 before you put the program together. It kind of gives you a really good roadmap as to what some of the pitfalls might be. So those are some of our thoughts. Those are some of the things that we think about when we work with our clients on, excuse me, on on executive compensation at a nonprofit level, with or without deferrals. We'd be glad to help any of you look at your existing plans or programs or put one in for you if you need. If you have any questions on today's webinar, by the way, I think this is a part of your exit when you sign off, but please send me as detailed a question as you want about anything we talked about, and I assure you I will get back to you over the next day or two and try to give you the best answer that we can. And for those of you that follow along in our employee benefit practice, the next webinar I'm going to do is going to be near the end of May. It's going to be on retirement plan service agreements. And I think whether you're on the service provider side or the plan fiduciary side, we're going to kind of really dissect and take apart some service agreements and look at some of the standard or more common provisions, describing services, compensation, fees, what have you, just kind of see how they're written up and how maybe that can be improved upon, as well as some of the more, I don't want to say boilerplate because it's all important in the eyes of a lawyer, but some of the stuff that people don't always pay attention to as much, which is, indemnification, arbitration, choice of law forums, consent to electronic delivery, and so on. So that'll be our next webinar. You'll get more information on that. This webinar today will be posted on our website, I think the recording and the slides, over the next day or two. So feel free to take it and share if you will. And again, don't hesitate to reach out and contact me with any specific questions that you have. Thank you very much for joining us, and I hope you have a great day. Thank you.